We got the media team in here. We're the media
We're the
team.
media team. We got content. TV's in the go. We got TV in the go, Wack.
You looking for that fire Clubhouse content? Well, you need to subscribe to the home. Hey, yo, Clubhouse TV. Let's get to the content.
That's a good one.
In the block.
Calling case 2:25 MJ 1494, United States of America versus Eugene Henley Jr. Counsel, please state your appearances for the record.
Paul, folks.
Good afternoon, Your Honor. Kevin Butler and Jenna McCabe on behalf of the United States.
Good afternoon. Good afternoon, Your Honor. John Targowski seeking appointment on behalf of Eugene Henley. He's present. He's in custody. He's being supported by his family and friends.
Good afternoon to you, Mr. Targowski, and to you, Mr. Henley. Okay. So, Mr. Henley, as you know, we're here today because you've been charged by the United States with a felony through a document called a complaint. What I'm going to do is start by reviewing some of the documents I received from you and your attorney. Then I'll have some questions for you, and then we'll talk about your case a little bit, okay? All right.
Yes, sir.
So, Mr. Targowski, I did receive a financial affidavit, but I understand that you are retained, so I'm just going to
No, I don't mean to interrupt. I'm part of the CJA panel and seeking appointment.
Oh, I'm sorry, my mistake.
I believe my client will be retaining private counsel. I've spoken to 2 private attorneys, so I would seek a provisional appointment.
No problem. Okay, so let me review the financial affidavit. This is my mistake. We'll take a step back. Here's what I would say. I do think it's questionable, Mr. Henley, that you qualify for appointment of counsel at no cost. In spite of that, I will appoint Mr. Targowski here today from the CJA panel. Here's what I'm going to say. If it sounds like your plan is to retain counsel.
Yes, sir.
Okay. If that doesn't happen, I'm just going to, Mr. Targowski, if you're not replaced by retained counsel in, let's say, 2 weeks, then I'm going to direct you to notify the court. And what I will do is I will require Mr. Henley to pay CJA rates. This essentially is a nominal rate that defendants who can afford to pay appointed counsel. It's basically like $170 an hour, which is far below what Mr. Targowski is worth. But it's something.
75 now, Your Honor. I think we got a slate.
All right, there you go. But really, if you have, for defendants who have the means to pay, that's what we require. So, but I'll go ahead with it. Up to 2 weeks will be free on the United States. Okay. Any questions about that?
No, sir.
All right. So the next document I'm going to review, Mr. Henley, is this advisement of defendant's statutory and constitutional rights. I'm holding up my copy of the document. This document describes your rights, Mr. Henley, as a criminal defendant under federal law and the United States Constitution. It looks like you signed this document on the second page. Is that correct?
Yes, sir.
Okay. Before signing the document, did you read it or have it read to you?
Yes, sir.
And do you feel like you understand your rights?
Yes, sir.
Do you have any questions for me about what your rights are?
No, sir. Regarding the documents.
Okay. And if you have questions at any time about your rights, you can always ask Mr. Targowski. He can give you confidential expert legal advice at any time. If you want to take a break and ask him questions, just let me know, okay?
Yes, sir.
All right. Mr. Targowski, do you agree that your client understands his rights?
Yes, sir.
Okay.
Paul, folks.
All right. So as I said, Mr. Henley, we're here because you've been charged through a document called a complaint. I'm holding up my copy of the complaint. Pretty thick document. Have you and your attorney received a copy of this complaint, Mr. Henley?
Yes, sir, we have.
Have you had an opportunity to review that with your attorney?
Yes, sir, we have.
Okay. Do you have any questions about what the allegations against you are?
No, sir.
Do you understand what the government is accusing you of?
Yes, sir.
Okay. Mr. Targowski, do you agree that your client understands the nature of the allegations against him?
Yes, Your Honor.
Okay. So, Mr. Henley, if you do have any questions in the future, I know you don't now, but if you have any in the future, you can always ask Mr. Targowski. And he has a copy of this, you have a copy of this, you can review it together, you can review it with the grand jury. You're entitled to something called a preliminary hearing. A preliminary hearing is a hearing at which the government would be required to present evidence to establish probable cause to support the charges against you. It's my understanding that you'd like to go forward and schedule a preliminary hearing. Is that right, Mr. Tarkowski?
That's correct. We're not waiting.
Okay. So I will schedule a preliminary hearing in this case for April 3rd, 2025 at 11:30 a.m. That'll be in this courtroom before Judge Kaufman. I'm also going to schedule a post-indictment arraignment date for April 8th, 2025 at 11:30 a.m. Also in this courtroom, also before Judge Kaufman. Okay?
Your Honor, the PIA is at 11:30 as well?
Yes. 11:30, April 8th. And then the preliminary hearing is April 3rd. Same time, same courtroom, same judge. Okay, no worries. I'm happy for you guys to chat. So what I'm going to do now, Mr. Henley, because this is your first appearance in this case before me, I'm going to instruct the government pursuant to a law called the Due Process Protections Act. That's a law specifically designed to protect criminal defendants such as yourself. Therefore, Mr. Butler, Ms. McCabe, pursuant to the Due Process Protections Act and Central District General Order 21-02, the court will order the government to comply with the disclosure obligations under Brady v. Maryland and its progeny, and the court reminds the government of the possible consequences of not doing so. Those include the exclusion of evidence, adverse jury instructions, dismissal of charges, contempt, referral to a disciplinary authority, and sanctions. Does the government understand its obligations and agree to comply?
Yes, thank you.
Okay, thank you. So I think those are all the preliminary matters, other than moving to the government's notice of request for detention. If I missed anything, let me know. Otherwise, the court is in receipt of a notice of request for detention. Mr. Butler, is the government still moving for detention in this matter?
Yes, Your Honor.
And have the parties reached any agreement on the government's request that I should be aware of?
Only that I believe the defense is going to be asking for continuance of the contested detention hearing.
Okay.
A date.
Thank you for pointing that out. Mr. Targowski, are you ready to proceed with the detention hearing today, or would you like a continuance?
I'd like a continuance to the 31st, Your Honor. I'm in consultations with more than one retained attorney who has asked me for that. I would schedule it sooner, but I have a trial before Judge Barat on Tuesday. And I talked to the government. I think if we set something on or around March 31st, that would give ample time for retained counsel to take over to properly handle a detention hearing.
Okay. So what you're contemplating is Monday the 31st.
Correct.
Is that what you'd like to do, Mr. Henley?
Yes, sir.
Okay. Let me see, what is today? I know. Today's the 20th. Oh, it's Thursday.
It's mostly due to my availability, Your Honor, next week. I'm in a week-long trial.
Okay. And are we going to have retained counsel to do the 27th?
I'm almost certain of it. I've spoken to an individual named David Chesnoff, who has already communicated with my clients, and I believe that's what his plan is. To retain that individual.
Okay. What if we, okay, so
I can handle the detention hearing if that doesn't happen on the 31st, but in order to accommodate my schedule, it couldn't happen next week.
okay. And the government has no objection to the longer than 5 days.
No, Your Honor.
Okay. Well, so
Given the seriousness of this charge, given that there's probably going to be 20 or 30 sureties, many of whom are here, that would have to be interviewed by pretrial services and evaluated, given that my client would probably research whether a property bond could be something we could pursue, given all of those things that really have a proper detention hearing, it may take longer than
understood. In some sense, I kind of feel like it's your prerogative because Mr. Henton, you will be temporarily detained pending this hearing. That's what we're talking about. Normally, we only continue up to 5 days. You are asking for more than 5 days. You're the one who will be held in custody until this hearing happens. So I kind of feel like if you want the extra time, it's It's up to you. So it's fine with me if it's fine with you, Mr. Henley. You can also move it, sort of, you can send us an email, and if you're able to do it sooner, we can make it sooner. Does that make sense?
Yes, sir.
So we can do it later at your request. It's at your request that we're doing it, so it's fine with me. I actually can't do it on the 31st, so it'll be the duty judge, I think is what will happen, or what will happen? Well, I'll find someone else to do it on the 31st. So if you do go forward on the 31st, I just won't be here that day. I will find someone to handle on the 31st, so you will not be waiting on account of the court. If you'd like to do it earlier, I'll do it earlier. I can do it any day earlier you want. I just won't be here on the 31st. So we'll be in touch with you about that. I will find someone to handle it on that day. So I won't be, Mr. Hamlin, you will not be waiting on account of me. Okay?
Thank you.
All right. I think I need to. What times work for you all, and I'll work with whoever's going to cover it for me.
That day, Your Honor, any day works. Anytime.
The government can make it time work, Your Honor.
Okay, we'll work it out and we'll notify you. We'll just shoot you a note. But we'll currently set it for the 31st. Again, if things work out and you want to do it earlier, your prerogative. Okay?
Thank you.
All right, so then I think that's everything. Am I missing anything?
No, Your Honor.
No, Your Honor.
Okay, all right. Thank you to the parties. So, Mr. Henley, we'll see you back here. We've got you tentatively scheduled sometime on the 31st. Your lawyer can shoot me an email if you guys are ready to go sooner, and we'll do it sooner. Okay?
Thank you.
This court is now in recess.
Means eyeglasses.
Okay.
I'd ask the court for a referral for that to MDC.
Okay. Can I ask the supervising marshal, is he being held at the MDC?
Deputy Cordova, yes, we'll most likely go to NBC and we'll get that to NBC for the medical.
Okay, I appreciate that. I just asked to confirm. So, Mr. Henley, it sounds like you're going to be held at the Metropolitan Detention Center. It's right there. It's right next door. It's actually quite an excellent federal detention center as far as those things go. I think it's quite excellent. What they will give you a medical screening evaluation upon your admission. So I will write down this referral that your lawyer has requested, but the best thing, in all honesty, is for you to be your best advocate. You'll get a screening evaluation, and so you tell them what you need and make it really clear. That'll help you get what you need as fast as possible. I will also send it in writing, and that will also help you, but I just wanted to sort of let you know, to sort of advocate for yourself, that they will ask you those questions, so please do speak up, and that'll help the process, okay?
Yeah, appreciate you. Thank you.
Okay, anything else?
Not by part, not by the
Okay. Thank you again.
Clubhouse TV. Clubhouse TV. Clubhouse TV.
What up, YouTube's Clubhouse TV, back with another one. And y'all already know, y'all heard the content, man. Big U made his first appearance in front of a federal judge today after being indicted under a sweeping RICO case that got deep ties to South Central LA. Now, the energy was tense. He walked in looking composed, suited up, no emotion on his face, but you could feel the weight in the room. The prosecution came out swinging. They claim Big U plays a key role in orchestrating a long-running criminal enterprise ranging from extortion to money laundering and beyond. Now, they're painting a picture of an OG who never really left the streets. Now, the RICO charge alone is no joke. If convicted, we're talking serious time. Prosecutors dropped the bomb saying they have surveillance, phone records, even cooperating witnesses. You already know, people talking. But Big U's legal team, he doesn't have one yet. As you heard in the content, looks like he's searching for a legal team. He wants to get some addressed for him. Now, the judge didn't rule on bail, said they need more time to review the evidence. So Big U stays in federal custody. I don't think they're going to let someone of his magnitude out, especially when he's looking at that potential murder for Rayshon Williams. His next hearing just a few weeks away, and trust me, it's going to be major. Now, this case could shake the city. If even half of what the feds are claiming sticks, this could mark the end of Big U's public legacy as a mentor and an activist. But stay tapped in right here with Clubhouse TV. We'll keep you updated with every twist and turn. Hit that like, drop your thoughts in the comments, and don't forget to like, share, comment, and subscribe. It's about to get real, y'all. Appreciate y'all for checking out Clubhouse TV. I'm on to the next one. Oh, any questions or suggestions? And if you need any advertisement on my channel with over 40 subs, just get with me on IG and I'll get right at you, man. They've been coming in, so I've been doing advertisement for people and they've been loving it. So hit me up and I'll get right back at you. I appreciate y'all checking out Clubhouse TV, and I'm on to the next one, y'all. Peace.